Well, Zahoor Ahmed Bhatt, the academic who came here and argued for a few minutes.
Yes.
Well, that's because he argued what he argued. He was suspended from the faculty. Because on 25th August, he took leave for 2 days, went back, and then he was suspended on the 25th of August. I mean, these things should not happen in our country. I'm sure the AG will look at it.
Mr. Attorney General, just see what Mr. Sibal is saying.
I have checked up, Lord.
Yes.
After having read in the newspapers,
Yes.
I did check up. And of course, Lord, the Advocate General is also here. But what is reported in the newspaper may not be the whole truth. He files petition.
It's not from the newspaper, Manoj. The order itself, 25th of August, I've got the order with me.
No, just a minute. Allow me. There are other issues. He appears in various courts, and there are other issues also. We can place it before your lordships. And
But
in
then
any
he should
case,
have been suspended earlier. Why might?
He gave written submissions.
Written submissions here. Manoj. This is not fair. This is not the way that our democracy should function.
Mr. Attorney General, just see what has happened. Somebody who appears in this court is
it's not the
suspended.
ground, but we'll look into it. We'll
Have a look into it and just talk to the
Without doubt. Without any doubt.
talk to the Lieutenant Governor and see what has happened. If there is something apart from this, that's different. But you know why in such close succession to his appearing before us.
Certainly, that will be.
23rd he appeared. The order refers to this. He appeared here and then next day he was suspended. Anyway, I just wanted to bring it to your lordship. I'm sure the attorney will use his good offices, Baladani,
Yes.
to something.
officers are here, it would be taken care of. It's not concerning this. Everyone has a right to appear before your lordships. It can never be by way of a retribution. There is something else, Lord,
Mr. Solicitor, the close proximity between the arguments and the order.
The timing is, Manoj, definitely not proper. I bow down. I bow down. Timing is not proper. No argument on that.
Timing and reference to this aspect, if it is there in the letter. I don't know, I have not seen the letter, I do not know. But if the reference to his appearance here is there, then there is a little problem. What happens to the so much freedoms in part?
Yes, yes. Absolutely.
Yes, Mr. Solicitor.
Lord, on Friday, on Thursday, Lord, your lordships, Lord, desired what happened to other assimilation of other states? My Lord, during the weekend, my Lord, we have undertaken that exercise. The documents were available in the National Archives. And the officials of the Home Ministry went in National Archives. They studied everything, and we have prepared a two-page note for that. My Lord, if your Lordship allows, I can, my Lord, immediately share it with others, my Lord, and
And what you can do, it since it was in response to a question of the court, you can just ask the nodal council to make it a part of your submissions as an annexure, so it won't get misplaced.
correct.
Make sure and circulate to the other side as well.
My Lord, right now, would your Lordships like to see
Yes, yes, we can see it right away, no problem.
No, I'll just, my Lord, kindly allow me to send the mail. It is sent.
Camilla?
It won't take more than, my Lord, it is sent. My Lord. And the other side.
Yeah, our whole line, there was no.
It's in fact a one-page note, my Lord, not even, rest is, my Lord, list of states. So we need not read the list. The figures would matter, my Lord, not the names.
In the meantime, if you have it for my colleagues on the.
My Lord, can I
Yes,
be
certainly,
permitted to
because-
circulate?
Yes, no difficulty, we'll see it, because it'll take a few minutes to otherwise come on the email.
One more. One more. One, I have already said this is from National Archives, coupled with, my Lord, facts stated in the white paper. I'm sorry, my Lord, my Lords,
Already now there on all the members of the bar will also get it on your screens in front of
no,
you actually.
it is now received. It is received.
It's now on the screens for everybody, yes.
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 First is, my Lord, we have said that this is combination of our research in the National Archives and white paper. Second, at the outset, it is necessary to clarify that the process of integration of princely states with dominion of India and or union of India was not a linear process. The merger agreements and instruments of accession, along with proclamations, did not operate in a step-by-step manner for every state. They represented various means of integration of princely states with the country, the signing of either of instrument of accession or revised instrument of accession or merger agreement or even a proclamation only, like Hyderabad state, is sufficient for integration with Union of India. Therefore, the list of princely states which fall under merger agreements are separate from the list of princely states which are covered with instruments of accession or revised instruments of accession. Therefore, broadly, there are two heads, princely states falling under merger agreements and princely states falling under instruments of accession followed by proclamation. Under the first head, princely states falling under merger agreements, the princely states were of two kinds. A, princely states with merge with the existing Indian provinces, they were British controlled provinces. And second, princely state with merge with states as centrally administered areas. Lord, some of the princely states desired that we should be directly governed. Some of them, Lord, were strategically so located that the
They became the chief commissioners.
chief commissioners provinces, your Lordship, sir. The next category of princely states, this is important. Table C are the ones covered by the instrument of accession, revised instruments of accession, followed by proclamations. The distinction between the two is of terminology and not a step-by-step linear process, as a large number of states directly signed revised instrument of accession without signing the pro forma instrument of accession before that. Therefore, the same is being clubbed and expressed as table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation accepting Indian constitution. It may be noted to the limited position emanating from the National Archives and white paper that these princely states did not sign any merger agreement. Lord, then your lordships would come to the next page. Lord, 1, 2, page 1 is, my lord, 1 to 32, then 33 to 65, then, my lord, 66 to 77. The lordships have, my lord? The rest is not available. Lord, please see, my lord, the states from Balasinore to Surgana were a part of one group which had a total of 144 states. They formed their own group. Therefore, my lord, they are 77 to 144. Then, my lord, total comes to 204. So we have started with 205. It goes up to 216. Then provincially merged Khasi states. Khasi states were essentially in the northeast, and, my lord, they are 241. Total, my lord, are 241. Then, if your lordship turns the page, this is table B. Princely states which were merged with states as centrally administered areas. Then, my lord, we have started with 242. It goes up to 302. We need not, my lord, read the names. These were, my lord, the states which were centrally notified areas. Now, my lords, may kindly come to para 7 at the foot. It is to be noted that the above agreements were signed by the Secretary, Department of States, Government of India. On signing of these merger agreements, orders under the relevant provisions of the Government of India Act were issued, giving legal force to these agreements. Then, my lord, table C. Princely states covered by instrument of accession or revised instrument of accession and proclamation, accepting Indian constitution, no merger agreements. There were several states which did not sign merger agreements. My lord, which we have started from 303, taking, my lord, the list from 302 on the earlier para, and it goes on till 580. So it is 555 plus 24 because Khasi states are separately dealt with even in the white paper. Therefore, my lord, this is the total figure which became a part of Union of India when Article 1 came into force. And, my lord, we have given the disclaimer that, of course, this is based on national archives and the white paper. But, my lord, as a matter of interest, my lord, the national archives, my lord, the officers, my lord, the joint secretary and others who went, well, it's worth visiting. It's very well maintained national archives. My lord, in some of the documents, you need to maintain a particular temperature so that the document is not destroyed. My lord, every care is taken since beginning. As an interest also, your lordships may not consider once visiting it, not for this matter, but there are several historical documents, several films. Films, not, my lord, as we understand, my lord. Some of the documents are filmed and they are preserved. Some of the speeches of our national leaders, my lord, whichever could be videographed in those days, are very well preserved. There are several maps and many, my lord, matters of historical interest. But the beauty is that since the beginning of the country, it has been preserved well.
Yes.
My lord, I was at page 47, my lord. And whatever is irrelevant, your lordships may, my lord, take it from me. Again, I have, my lord, diluted, and I will not take much time, my lord. Whatever may be relevant to be put here as a completion of chronology, I have put it, I will not read it, my lord. Page 47, my lord. Now, my lord, this is after India attains independence and the constitution is adopted. My lord, constitution is adopted, my lord, we are aware, my lord, 26th of January, 49. 26th November, 49. I'll just check up, my lord, our impression is subject to verification. Article 1 came on that very day. From the beginning, Article 1 is there, subject to, my lord, verification. Lord, page 47, CO 10.
Yes.
I'll just orally point out what it contained two aspects. My lords are aware, my lord, Article 371A, which provided that first take the list of 3 entries which the instrument of accession maintained, that is defense, communication, etc. And the president was to find out which are the corresponding entries in the union list. Because defense can have 5 corresponding entries, communication can have wireless, telephone, etc. 5. So, my lord, first act, my lord, which I have mentioned is that, my lord, with which your lordships may directly not be concerned, just by way of, my lord, an example that the Honorable President, by this first CO, identified the entries. That these entries would fall within those 3 broad subjects which the ruler has given under the instrument of accession. Then it is exercise of powers under 371D and applying these provisions of the Constitution of India. Your lordships would find, I'm not reading union, relations between union and states, but all were applied with modifications. As Article 370 or itself, my lord, points out, for example, amendment of the Constitution. 368 was applied, but with a provision in sub-article 6 that any amendment made in the Indian Constitution would not ipso facto apply to the Jammu and Kashmir
You
state,
follow the Article 370 route.
unless, yes, unless applied through Article 37. So, my lord, in that fashion, Lord, the second part of this CO 10 is,
The first part was with consultation, the second part was with concurrence.
with my lord, concurrence. Concurrence, my lord, consultation is only qua.
There's a slight, as far as 368 is concerned, the constitution can be amended in terms of that article by the parliament and so forth. Now, as far as proviso to 368, it says that the legislative assembly can then adopt or with concurrence, then it will apply over. Whereas D requires concurrence. Concurrence probably will be prior concurrence.
My lord, that would be so.
Because when we are talking about constitution as it exists, 371D refers to the constitution as it was originally enacted.
Yeah.
368 refers to the amendments to thereafter. So there is a slight difference between the two.
Yes, my lord. So whatever amendment is made in any part of the Constitution would not apply unless it is so applied either fully or with modification and exception under 371D route.
It will be 371D route or 368 route.
No, it would be 371D route. So I'll tell you, lordships, why. Lord, suppose the Indian Parliament amends.
Some audio ways.
For that,
68 is not in this red book, no?
no, my lord, it is now deleted, my lord, therefore.
No, but this red book has a lot of other things, but some of the others
Yes,
not here.
my lord, would your lordships like to see, my lord, the original the CO? My lord, that your lordships would find
It
at
should be here actually.
volume 3.
होना तो चाहिए, देख लो. उसमें.
Lord, let us take a hypothetical illustration, Manoj. Just, my lord,
It's just a matter of logics, that's all.
Yes, but only 2 minutes, my lord. The concerned amendment, my lord, in this CO is at page 4 and 9, 4 to 9, in volume 3,
Volume 3, right?
CCD. Please come to, my lord, page 8, my lord. The directly, my lord, page 8. And I'll give one illustration only, my lord, at the foot, my lord. Your lordships have, my lord, 360, my lord, part 12, part Roman 12. I'm sorry, part Roman 20. My apologies. Part Roman 20, my lord.
Which page are you?
Page 8, volume
page
3, the document volume 3, PDF page 8. This is, my lord, the concerned CO 10.
Unless applied by order of the president and a clause.
Provided, I'm sorry.
Yes,
My
you
lord
got it.
Justice Khanna gets me.
Page
Provided the proviso article 368 shall apply subject to the additional proviso, provided further that no such amendment shall have
Just
effect.
1 second. One.
This talks back to article.
Yes, my lord, I'll just give an illustration.
It says.
Yes,
371.
my lord, just to illustrate, my lord, for example, Constitution of India amended and inserted Article 21A, right to education, free education, etc. It never applied to Jammu and Kashmir till 2019 because this route was never followed.
Likewise, as you said, the preamble amendment of 1976
Was
what is it?
applied with modifications, etc.
So the secularism and socialism amendment was never adopted in the case of
Yes.
Jammu and Kashmir.
Yes, even integrity word is not there. That was also not applied.
We can skip this now. We can go ahead.
Yes. My Lord, this is contemporaneous. Your lordships would find the date. It is 26th of January, 1950. So contemporaneous, nothing, my lord, much turns on that. Your lordships may, my lord, directly come to page 49.
Page 49 of the same volume.
Of my written submission. I'm sorry, my written submissions. Lord, it is respondent conjoint written submissions.
Yes.
Written submission, volume 3, my lord. Lord, 1st May, your lordship gets the date. My lord, the Chief Justice gets it. 1st May 1951, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected constituent assembly to draft a constitution for the state of Jammu and Kashmir. Please don't read the note, my lord. I'll orally point out what it says. Lord, when I take your lordships to the position of Jammu Kashmir Assembly vis-a-vis our constitution, my lord, the Constitution of India and the Constituent Assembly of India, Lord, I read that proclamation just to show that it was intended to be subservient to and subordinate to the Constitution of India. But right now, this is a date that the Constitution.
Mr. Solicitor, you may deal with this, what I'm suggesting, but I'll forget it. So, I was reading a list of dates in the morning, the thought struck me.
Yes.
At one level, you may be right, or subject, of course, to what we have to consider on their rejoinder, that your argument is that the Constitution for the Republic of India is really a document which lies on a higher platform than, say, the Constitution of the state of Jammu and Kashmir. That J&K Constitution, according to you, is subordinate to the Union Constitution. That's one aspect. The second aspect, which you have tried to make out in your note, which we may elaborate it upon it later, which is your contention that, look, the Constituent Assembly of J&K was in the nature of a legislative assembly and not a constituent assembly. That, strictly speaking, that there may be a problem for two reasons. That's not how Article 372, bracket 2 refers to it. It refers to it as a constituent assembly of the state.
Correct.
But more important, once Article 238 made certain provisions of the Constitution inapplicable to the Part 3 states, and particularly the state of Jammu and Kashmir, including executive, legislature, judiciary, which would be brought into force by the Constituent Assembly framing a constitution for the state of Jammu and Kashmir, then it may be very difficult to call it a purely just a legislative assembly. That is an aspect which you may want to deal with. You may deal with it in just one
Because that
sentence,
is
and
a
then maybe
separate segment, my lord, of my subject.
then we will deal with it at that point.
I'm
on the
obliged.
list of days.
I'm obliged. My lord, rest of the 3 dates your lordships can, my lord, ignore. Kindly come to page, no, not ignore, my lord, skip. Sorry, my lord.
And we have read Sheikh Abdullah's address was read out to us by the other side. So we
I'm not
need
reading, my lord, any address now. I'm just on the chronology,
Yes,
and
yes.
chronology which is relevant right now.
Absolutely,
Which
you can
would,
go.
rest
Yes, yes.
is, my lord, for completion, but may not, my lord, invest your lordship's time. Then, my lord, Constituent Assembly is created. Now, my lord, comes CO 39, that is 1952 CO. Lord, please see, under Article 371, Lord, these are all, appears to be, my lord, powers under 371D, but all COs mention it as 371. Maybe making a little broad source of power. Of the Constitution of India, in following consultation with the government of Jammu and Kashmir, the President issued the so-and-so order 1952, modifying Article 54 and 55 of the Constitution insofar as it applied to the state of Jammu and Kashmir. By this CO, for the first time, President recognized the Constituent Assembly as the Legislative Assembly for the purpose of election of the President of India. Your Lordships would, my lord, note, when Constituent Assembly of Jammu and Kashmir was formed, obviously there was no Legislative Assembly because that was yet to be a part of the Constitution to be framed. So as to ensure that they do not lose their representation in election of the President, Lord, this CO was issued that you will be treated as Legislative Assembly also. Lord, your Lordships would find at the end of this chronology, 370 has been applied in kind of a floating way. Whenever, my lord, it is required to use the word interchangeably, it is logically so used, and whenever any word has become otiose, it is replaced by its successor. Lord, this
At that point, there was no legislative assembly at all.
at all, correct. I say,
Therefore, they had to make this CO
correct.
to read that instead of the word legislative assembly shall also include a reference to constituent assembly. Because at that point, there was no legislative assembly.
My lord, exactly that is where, my lord, I would respectfully drive it. When there is no legislative assembly, constituent assembly, the president has said that now it would be treated as legislative assembly. But that I'll come little later. Lord, it has been used, my lord, kindly see there are two, my lord, prominent features in COs which comes up.
Yes.
A, it has been used in a floating way, some words used interchangeably. And second, and most important for my purpose, whenever a word in Article 370 becomes otiose, for that post not being in existence, that body not being in existence, it is immediately replaced by its successor. Sadr-e-Riyasat is replaced by governor, etc. Now, my lord, your lordships may come to the next date, 20th of June, 5th. There was a letter, my lord, referred to by Mr. Gopal Shankar Narayan, where Dr. Rajendra Prasad, the then Honorable President of India, writes to the Prime Minister, Honorable Prime Minister Nehruji, that this can be used only once, etc. that is that can be used, my lord, in buttressing the arguments which I am also advancing. But we also got, my lord, the response of the Honorable Prime Minister. I'll put it, my lord, when that fact comes, my lord. And thereafter, the same Honorable President issued, my lord, order under 370 sub article 3 also. So, my lord, literally, actions speaks louder than words. That was, my lord, the understanding, but the understanding was that it is so drastic a provision that use it only once. It's an self-extinguishing provision. That's my lord, the tenor of that later. My lord, while the Constituent Assembly of Jammu and Kashmir was in session, Lok Sabha also continued its session. In New Delhi, as per Constitution of India, during one of the Lok Sabha debates, my lord, please see, my lord, how our parliament understood Article 370. My lord, the purpose is to satisfy your lordships that Article 370 is not just stated to be temporary. Legislative Assembly debate says it is temporary. Even during the subsequent parliamentary procedure also, everyone treated it as a temporary measure. But only for that, but this is N.C. Chatterjee. But incidentally, he was the counsel in Premnath Kaul judgment. N.C. Chatterjee, he must be a member of parliament also. I'll just read the underlined portion. I maintain and I say that with all earnestness that under the law, under Constitution, accession to the dominion of India under Section 6 of the Government of India Act, as amended after the Indian Independence Act, was final and irrevocable, and there ought not to have been any question of plebiscite. I maintain that accession is final and irrevocable. Under our constitution too, Kashmir is an integral part of India. Under Article 1, the Indian constitution consists of federation of states and it is a part B state. There cannot be any going back on that. But the unfortunate thing is that the Constituent Assembly is doing something there which is against the spirit of our constitution. I know my honorable and learned friend Dr. Kaju will point to me Article 370 of the Constitution. Article 370 is part of Chapter 1221 and it deals with temporary and transitional provisions. Then, Dr. Mukherjee, in a democratic federal state, the fundamental rights of citizens of one constituent unit cannot vary vis-a-vis the citizens of another unit. Are not people of Jammu and Kashmir entitled to the fundamental rights that we have given to the people of India minus Jammu and Kashmir? There is no scope for varied constitutional patterns, disparities as between one federating unit and another. The legislative or executive authority of the units in respect of the states will be coextensive with the similar authority in and over the provinces to certain adjustment during the transitional period, the fiscal relationship, etc. Then, my lord, Pandit Ji, as the Prime Minister and Minister of External Affairs, responds. So, Kashmir obviously is a constituent unit of the Federation of Union of India, but a difference has subsequently arisen. You please remember that, not originally, between Kashmir and other states, because subsequent to the earlier accession, the other states have become integrated, more which Kashmir has not and could not in the circumstances as I have tried to point out. But nevertheless, it is a full constituent unit of India. Various things flow from it. Various consequences. Consequences, for instance, in regard to the President of the Republic. The President has certain authority which he exercises on behalf of Republic, and wherever the constituent unit may be, the President will exercise that authority in that measure. But come to the last line. But the President's ultimate right has to remain for a constituent unit of India. That irrespective of 370, the President of India's right, which he exercises on behalf of the Republic, which he exercises on behalf of we the people of India, must remain as a plenary power without any fetters. My lord, that's how the Parliament understood. My lord, thereafter, my lord, your lordships would come to, my lord, page 52. First 2 days, the dates your lordships may skip. My lord, during the Jammu and Kashmir Constituent Assembly debates also, my lord, I have quoted, but I may, my lord, just paraphrase it and proceed further. Lord, it says, every member says that this is temporary. They also understood it to be temporary. Well, I am not laboring on the point right now why it is temporary. The point is, which I will ultimately make, despite full knowledge that Article 370 is a part of the Constitution, despite having accepted in the Constituent Assembly debates of Jammu and Kashmir that it is temporary, they chose not to make any recommendation under sub-article 3. My lord, that's a separate limb, and my lord, I'm just flagging it here. Kindly see, my lord, highlighted part. This assembly came into being because of section 370 of the Indian Constitution, and it was because of the section that we enacted such laws as were necessary for our society. So, my lord, they understand that its very source of existence was Constitution of India. Lord, kindly come to page 53, third. Lord, this is third date, 15/11/52. Lord, this was the first use of Article 370, sub-article 3. So kindly note this.
Yes.
Yes, my lord, kindly allow me, my lord, to point out. My lord, this might appear to be striking because it is striking. It should never have been at the first given and should never have been continued. The effect of 370 with 367 or any provision of the Constitution is that by an administrative act of the Honorable President and the Government of the state, any part of the Constitution can be amended, can be altered, can even be destroyed and not applied, and new provisions can even be created in Constitution of India. 35A, I'll come to it. Article 35A was created, which is a part of Constitution of India, only to be applied to the state of Jammu and Kashmir. That's why, my lord, this 371 route and 367 mechanism has been used more than once because 370 permits it. It stopped, my lord, only after 5th of August 2019. Otherwise, any provision, any article, my lord, it was placed much at a higher pedestal, as my Lord Justice Call rightly pointed out, than even a basic structure. Please see, my lord. Constitution application to Jammu and Kashmir, Order 52, was issued by way of the state presidential order issued under Article 3701D. The first exercise is 3701D. The term Raj Pramukh used anywhere in the Constitution of India, Jammu and Kashmir being a Part B state, was replaced by Sadari Riyasat of Jammu and Kashmir. My lord, because in Jammu and Kashmir, Raj Pramukh was not there, Sadri Riyasat was there. So, wherever one authority ceased to exist, it was replaced by the successor authority. Now, the second part which is done, similarly, with a CO 44, there are two COs, my lord. Explanation to clause 1 to Article 370 was modified by the President in exercise of his powers under Article 370, sub-article 3, on the recommendation of the Constituent Assembly. My lord, because there, at that point of time, Constituent Assembly was in existence. So, the proviso to sub-article 3 could be operated. Therefore, it was so recommended, and the President added these words: the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadri Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in force. Well, the purpose of pointing out is that 370 has continuously been evolved depending upon the need of that situation. situation at the point of time. Earlier, it was Maharaja. Since Maharaja ceased to exist and Sadr Riyasat came, it was modified using 370 sub-article 3. And since Constituent Assembly happened to be functioning, it was with recommends. I'm sorry. Now, Lord, your Lordships may kindly come to page 54. CO 48. Lord, that is 14th May 54. Lord, several other provisions were applied. But your Lordships may right now only mark fundamental rights. How it was applied is really shocking, and I'm using that word consciously. But what was not applied is also interesting at the foot of page 54, which continued not to apply till 5th of August 2019. That is, my lord, at the foot your lordship gets, my lord, notably. I'm sorry, but I am on page 54, my lord Justice Khanna may see.
Yeah, I've got it.
Lord, fundamental rights just mark that they were applied. But what was not applied, notably, it did not apply the following parts at all. That is, directive principles of state policy, the states in part B, and scheduled and tribal areas. You know, tribal areas and any tribal reservation, etc., never applied in the state of Jammu and Kashmir till 2019. Now, the preamble was applied. Lord, your Lordships are aware, preamble is not treated to be a part of the Constitution, and therefore, my Lord, it is separately applied. I am not repeating. The word socialist and secular was not applied. Of course, they have put it in the directive principles. But directive principles are amendable by legislature. Your Lordships are on page 50.
Yes.
Lord, kindly come to foot of page 55, because this, according to me, Lord, as a student of law and as a citizen also, Lord, is something very, very serious. Other notable features, my Lord, by this CO, what was done? It provided for a separate provision for permanent residents of Jammu and Kashmir in Article 7. That is, my Lord, citizenship of Indian Constitution by inserting 35A.
Yes.
Then it removed references to scheduled tribes from Article 15, sub-Article 4. So, one, you alienate those who do not fall within the artificially created definition of permanent residence. Second, you alienate those who belong to scheduled tribe. Then, this is important, Article 19, 22, 31, 31A and 32 were applied with some modifications, and I'll show which modification. Surprisingly, in Article 19, please note this, my lord, this is something really shocking. And for 25 years, this continued. I am arguing this matter not from the point of view of center succeeding or state succeeding. How 370 operated on the people of Jammu and Kashmir. Because of 370. That's what, my lord, my attempt is. Surprisingly, in Article, I'm sorry.
Yes.
Surprisingly, in Article 19, the following sub-article 7 was added by way of modification which remained till 1979, for 25 years. And what was that?
Yes.
Article 19, sub-article 7, as applicable to the state of Jammu and Kashmir, the words reasonable restrictions occurring in clause 2, 3, 4 and 5 shall be construed as meaning such restrictions as the appropriate legislature deems reasonable. Lord, the citizens apply fundamental rights against the state, and now the legislature would decide what are the reasonable restrictions.
Other provisions of part 3 were applied without any modification.
There is a modification,
35C is there.
35C, my lord, and that is more draconian, my lord, if I am permitted to say so. Because that directly affected the personal liberty of the entire population of Jammu and Kashmir.
Preventive defense.
Preventive duty. 21 and 22 would not apply. But it's unthinkable in any constitutionally governed civilized society that Article 21 and 22 would not apply. Please see, my lord, Article 35C was added. Our India's constitution was amended by the government of India in consultation with the state government, adding this sub-article. Lord, see, no law with respect to preventive detention made by the legislature of the state of Jammu and Kashmir, whether before or after the commencement of the Constitution Order 1954, shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such law shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the said order, except as respects things done or omitted to be done before. Lord, this 5 years became 10 and thereafter it became 15. It continued till 1974. And my lord, most interesting part which I found,
Mr. Solicitor, you are appearing for the government of India, which did all this.
yes, my lord, I'm saying.
In constitutional theory, the government of India
Government
is
of
a,
India
is a perpetual
is
entity.
succession. My lord, the government of India has a right to say that this ought not to have been done and correct itself, which we did, and I'm justifying that correction. So I'm not saying that government and this government. It's our government.
Because in constitutional doctrine, the government of India is one perpetual entity.
Perpetual entity with perpetual succession, my lord. And therefore, my lord, the justification, my lord, which I am trying to give is that the mistake of past should not befall on the future generations. And that's why what we did in those days, I am justifying, my lord, I am justifying our undoing it in 2019. Yes. My Lord, one very interesting angle I found out, my Lord, while researching this on this question. My Lord, in Premnath call, some person was, Mr. Kaul was, Premnath Kaul was detained under preventive detention law. He approached this honorable court under Article 32, challenging his detention. The learned Attorney General, then, my Lord, appearing for the government, took the contention that 32 petition is not maintainable because it would lie only for violation of fundamental rights, and for Jammu and Kashmir, Article 21 and 22 are not fundamental rights. Fortunately, my lord, the court did not go into that question and decided it on merits. I'm sorry, Sampath Prakash, not Premnath. That was, my lord, the position of the 35C. Fundamental rights, your lordships have said 21, 22 is the heart and soul of the entire chapter 3. That was not applicable. It could be dispensed with while making a law for detention. Then, my lord, 35A was added. Please come to, my lord, page 56. And this, my lord, if we were to believe, resulted in several consequences. Please see 35A, amended in Constitution of India only to be applied in one state of Jammu and Kashmir. Please see, madam. One artificial class was created. Notwithstanding anything contained in this constitution, that is Constitution of India, no existing law in force in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state defining the classes of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or conferring on such permanent residents any special rights and privileges, or imposing upon other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or right to scholarship and such other forms of aid of the state government may provide shall be void on the ground that it is inconsistent or which with or inconsistent with or takes away or abridges any right conferred on the citizens of India by any provision of this part. A separate category of permanent residents was created, and any law which provides for this kind of special privileges would not be hit either by Article 14, Article 19, or any part of the Constitution. And that demarcating line from which date a person should be treated to be a permanent resident was, I think, 35. Yeah. Who's
35A challenged on the ground that it violates the basic
The
structure?
35A, it is, there are 5 petitions pending. Vipul.
No, but that's, before that it was never challenged.
They were challenged at the relevant point of time, could never be decided. I think, since long. Lord, kindly see, my lord, the impact of this. The cutoff date was, my lord, I am told 1927. So whoever came in Jammu and Kashmir in 1927 were permanent.
That's the law, what is the provision itself? It says it not, the judicial scrutiny is therefore prevented because
Now, the impact was, for example, people from Jammu and Kashmir, people from Pak occupied Jammu and Kashmir, Pak occupied Kashmir, POK, were driven out, both Hindus and Muslims. But they were driven out in 47 during those raids. They are not permanent residents. They were not permanent residents till 2019. There were large number of Safai Karmacharis who have filed a petition, my lord, or intervention application, who were brought from other states to do, my lord, the manual work of cleanliness, etc. They are not permanent residents. They are not getting any of these benefits. Despite living for decades together, no person, my lord, beyond outside Jammu and Kashmir can acquire property, meaning thereby no investment.